How to get a high grade in your EU law exam or assignment. The first thing you should do, well, first of all, I'd like to introduce myself. So my name is Nini. I'm founder of Simple Studying. I have LLB and L1 degrees from City University of London, and I've got high 2-1 and first class grades in my assessments at law school. I founded Simple Studying to help law students like you get high grades. We are creating AI-powered higher education and career building tool. After tremendous success we've had with legal education, we decided to build something big, something much bigger. So now we are building a digital platform, which will be like all-in-one platform for UK and US university students to get high grades and build successful careers. We have already 25,000 registered customers on the platform in the UK. That's like 25% of all the law students in the country. 90% of our regular customers who got a premium subscription, as well as tutoring sessions, at least 6 hours per module, have reported to have got a first class. So our system definitely works. And most of our students who follow our advice do get a first class. After working with thousands of law students, we know exactly how to get a first class law degree. Here are the key topics you should revise for your EU law exam. Free movement of goods, direct effect and state liability, Brexit, free movement of persons, preliminary rulings, and annulment. I strongly recommend you review the lectures in your university and see if there is any other topic that was emphasized on that could come up on the exam. But usually these are the topics that are examinable on EU law exams, and make sure you know these topics. Knowing those topics is not enough. Like, it's just a start. It's like half of the job. But the other half, for you to get a high grade or even pass your exam, you need to be able to answer problem and essay questions. So you may know what is free movement of goods, but you may not be able to answer a problem question about it if you don't practice, if you don't know what is the ARIC structure. ARIC is issue, rule, application, conclusion. So you have to start by discussing what is the legal issue. Students often confuse this by just rewriting the facts of the problem question. That's not what the legal issue is. The legal issue is the legal issue. So, for example, if there is a problem question about free movement of goods, the first legal issue you would need to address is whether or not the goods in the problem question is a good for the purposes of the EU law. There is a case called Arch Treasure's case that provided the definition of what is a good under EU law. It has to be a good valued for money and subject to commercial transactions. And then you have to apply it to the facts of the case and conclude whether or not this is a good. So that's the legal issue. Then a rule. So you have to say what is the relevant law and cite the relevant authorities. If you just say what is the law without citing it, it won't count. You have to cite the relevant authorities and the correct ones. Application. Then you have to apply the law to the facts of the case and provide analysis. Most of the times in law, you don't have just one answer. It's not math. So you will have to provide analysis because there are like multiple answers and you have to identify all possible answers and then critically analyze which one is more possible to happen. Your goal for a first class should be to identify 80% of all the legal issues that arises in the problem question, because it's almost impossible to identify it all. That's why nobody gets 100% in law. And then after you identify all the legal issues, you have to provide like perfect level of critical analysis, which is extremely hard. And that's why we highly recommend you get tutoring sessions at Simple Studying to tackle this issue. What is free movement of goods? There are 4 freedoms in the European Union that you need to be aware of. Free movement of goods, persons, capital, services. Free movement of goods is like cornerstone of the European Union. The goods, the products must be moving freely within the European Union from one country to another. And there should not be anything that prevents any free movement of goods. But what is a good? You have to start answering the problem question about this topic by defining what is a good. Good is a product that can be valued in money and be subject to commercial transactions. The case to be cited for this principle is Commission versus Italy art treasures. Identify if it's a financial or non-financial barrier to trade. That's the second legal issue. So you would write, it should be discussed if the barrier to trade is financial or not financial. That's the legal issue. And then you have to define what is a financial barrier and what is a non-financial barrier and say which one it is and why. Financial barrier is a tax barrier, so monetary measure, customs duties. So if the country is introducing a tax, that would be a financial barrier. The relevant provisions is Article 110 TFEU and Article 30 TFEU. You should be citing these provisions when you are answering a problem question about this. And Article 110 states, no member states shall impose additional taxes on products coming from other EU member states. So whatever taxes already exist on the relevant products, no additional tax can be imposed on products that are coming from other member states. Article 30 prohibits customs duties and charges having equivalent effect altogether. So it's prohibited. No member state can impose additional customs duties or charges just for the goods coming from other member states. Non-financial barriers. These are something that is not related to monetary measures, other kind of barriers to trade. There are two kinds of non-monetary barrier. There is one quantitative restriction and measures equivalent to quantitative restriction. You have to know which one is what and then cite the relevant case for it. Quantitative restriction, non-tax barrier to the free movement of goods. The definition is coming from the case of Geddo. Measure which amount to total or partial restraint of imports, exports, or goods in transit. That's the definition. So it has to be some kind of total prohibition or partial prohibition of import or export of certain goods. Then MEQRs, what is that? MEQR is not direct prohibition of trade, but it's some kind of a rule that indirectly hinders trade. The definition is coming from Dassenville. So if you have a total or partial prohibition of trade of certain good, then you have to cite Geddo case quantitative restriction. If you have not a complete restraint of import or export of a certain good, but a rule that could potentially prevent free movement of goods, then you have to cite the case of Dassenville and MEQRs. All trading rules capable of hindering directly or indirectly, actually or potentially intra-community trade are to be considered as measures having an effect equivalent to quantitative restrictions. So directly or indirectly, actually or potentially. So it doesn't have to be very obvious, even if it's indirect barrier to free movement of goods. It can be MEQR under the definition of Dassenville. What is direct effect? Direct effect often comes up in a problem question with state liability. So make sure you know both and you're prepared to answer a problem question of both topics. There are three kinds of laws in European Union. There is one regulation. These are directly effective. As soon as the regulation is passed by the European Parliament, it just directly affects all the member states. And the second one is directive. This one is not directly effective. It requires implementation. So when a directive is passed by the European Parliament, all the member states have a deadline to implement it. So it's like guidelines. They tell the member states what kind of legislation to enact, and they give them a deadline, but they have freedom to figure out the details. They don't tell them exactly what to write in the legislation, but they do tell them what objectives should be achieved. There are some guidelines, but they give the freedom to the member states to figure out the details. After the deadline passes for implementation, directives have a vertical direct effect. There are some cases when member states just don't implement the directives. If they don't implement the directives, it's a breach of EU law, and this directive becomes directly applicable after the deadline passes, but only vertically, not horizontally. There is this rule that directives do not have a horizontal effect. There are exceptions, though, to this rule that directives don't have a horizontal effect. Two kinds of exceptions: emanation of state and state liability. Emanation of state, there's a test for it. So these 4 requirements right here must be satisfied. First, measure adopted by the state, provision of public services under the control of the state, special powers. So basically, if an organization against which the case is being brought is under state control, has some special powers, it could indirectly be considered as a government institution, and therefore it could have a vertical effect. It could have a horizontal effect in this case. If you don't know what is vertical and horizontal effect, I can define it quickly. So vertical effect is when a claimant is bringing a case against the government or government institutions. So individual versus the government, that's why it's vertical. And then horizontal is individual versus another individual or a company. So that's why it's horizontal. And the other exception is state liability. State liability is obligation imposed on national courts to interpret national legislations compatible with EU legislation due to supremacy of EU law concept. So this is basically an additional remedy that EU citizens can claim if directive was not implemented and if their country is breaching their obligations under EU law. But the other exception that I haven't noted here, but I can tell you about it, it's indirect effect. So indirect effect basically means that even though directive was not implemented, it is still indirectly applicable because of the supremacy principle. We know that EU law is supreme. It's above all the national laws. So all the laws, all the national laws must be interpreted according to the EU law. That's indirect effect. But state liability is an additional remedy that EU citizens can claim, basically suing the government for failing to implement EU law measures like directive. This state liability comes from direct effect and supremacy principles. So when member state breaches their obligations and a citizen is affected, for example, a citizen was conferred rights under the directive, and then her country failed to implement that directive, and her rights were affected as a result, she could potentially sue her government. But the breach must be sufficiently serious. So the claimant must have been sufficiently affected, must have suffered loss. See the case of Frankovic on simple studying to learn more about this state liability. Frankovic is the key case for state liability, so you should know about this case. Brexit. Brexit is another big topic in EU law that you should know about. So Brexit, you know that this is when Britain exited the European Union, and you should know the act, the name of the act. Please memorize this. If you have an essay question about Brexit, you should know the act. This is the European Union Withdrawal Act 2018. UK left the EU in 2020, but the Withdrawal Act, was passed in 2018. Usually there is an essay question, and most of the EU exams I've seen recently in the last couple of years, there is always an essay question about Brexit. So make sure you know which act was enacted for the UK to leave the European Union. What is the name of the EU-UK trade agreement? It's called TCA, EU-UK Trade and Cooperation Agreement. You have to know this name, which established the new legal framework after the UK left the EU. And what are the advantages and disadvantages of leaving the European Union? Well, the obvious advantages is that parliamentary sovereignty was restored. Before, UK Parliament had to comply with EU laws. So it was no longer sovereign entirely, because the Parliament made law could have been disapplied, cancelled, if it was not compliant with the European Union law. So the Parliament, the EU Parliament was more supreme than the UK Parliament, which is obviously against the parliamentary sovereignty principle. And that was one of the reasons why Brexit happened. UK Parliament can make or unmake any laws right now disregarding the EU law. They don't have to comply with the EU law anymore, but not entirely. According to the EU-UK Trade and Cooperation Agreement, lots of previous law, EU law, that they had implemented in the UK was retained. So they still have to comply with lots of EU laws that was enacted before Brexit. And the disadvantages: harder to trade with EU. These are the disadvantages. So basically now, if British businesses want to sell in the European Union, they have to comply with extra regulations. They have to comply with both European regulations as well as British regulations. Whereas before, as long as they complied with British regulations, they could freely trade with European Union. So that's the disadvantage. But the good thing is that UK is now working on better trade agreements with other markets other than European Union, such as US and India, for example. They have now negotiations going on with other markets to have better trade relations. Free movement of persons. Article 18 TFEU 20 and 21 are the most important provisions about this. Article 18 states that discrimination on grounds of nationality shall be prohibited. Article 20 states that every person holding the nationality of a member state shall be citizen of the Union and the right to move and reside freely within the European Union. So this topic is basically about the rights of the EU citizens to go to any EU member state and reside freely without any immigration controls, and even take their family members if they are not European citizens. So the directive that you should know about is Citizens' Rights Directive 2004/38, where these EU citizenship rights were enforced and strengthened, and it was recognized that EU citizens can even bring their family members to move and reside freely in a territory of another country. Preliminary rulings and annulment. That's another topic that often comes up on EU law exams. The key provisions are Article 267 and 263 TFEU. Under Article 267, the CJEU can give preliminary rulings. So this is basically interpreting the treaties. If the national court in any European country is not sure about how to interpret a certain European treaty or a certain European act or decision of the institution, they can just refer to the Court of Justice of the European Union, the CJEU, and ask them how to interpret it. If the CJEU already has a judgment about the issue at hand, then they don't have to refer to the CJEU to make a judgment on the issue that already has been decided. Under Article 263, EU citizens or organizations can apply for annulled. This is when a legislation or regulation or decision was made by EU institutions, EU authorities, and somebody wants to get it annulled, basically. They can apply to the CJ EU or to their national courts as well to review the decision or legislation or regulation and get it annulled if it infringes any essential procedural requirement, any rules under the EU law or treaties, or if there is a misuse of power. For a first class in EU law, I highly recommend that you study using our materials. We have all the main topics in EU law on Simple Studying platform, condensed and oversimplified, made by top law graduates from English universities, and everything is just simplified for you, so you don't have to read thousands of pages from overcomplicated law textbooks. Also, you should get one-to-one tutoring because that's very important. Just knowing the law is not enough. You have to be able to answer essay questions and problem questions and be prepared for the exam. And that can only be achieved if you get at least 6 hours of tutoring with one of our tutors. So the best thing you can do is study with our materials and get at least 6 hours of tutoring with one of our tutors to help you prepare for EU law exam.